So, as we continue with our look at the subject of intellectual property, we want to continue from where we left when we talked about the introduction to intellectual property. So, just as a recap, we looked at the definition of intellectual property. What is it? What makes up intellectual property? We also talked about the major branches of intellectual property as highlighted in this slide. Then we wanted to talk about the economies of IP. Why intellectual property? Why is it important? It is very important. It is very critical that as you look at the subject of intellectual property, you need to have a better or a deeper understanding of its importance to human development, to human life, to economic development, to business, to institutions, or to you as an individual. So it is very important that you have an understanding of why IP is important. Then we started to look at the introductory components to the various types of IP. So we talked about a patent, which we said is an exclusive right that is granted for 20 days to the owner to exploit or to benefit from his creations. And this exclusive right comes with economic rights. It also comes with the rights to determine who uses or who can exploit or who can collaborate. All those rights are exclusively granted to the owner of the patent. Then we talked about the criteria that makes your innovation qualify for patent protection. We also talked about the various routes that are there to protect intellectual property. So it is very important that you remember or you have an understanding for each type of intellectual property. What are the routes or what are the options that we have when you want to file for IP protection? And basically there are three routes: the national route, which is governed by national laws of each country; the regional route, which is governed by the regional IP agreements; the international route, which is governed by what? By the international IP agreements. Then we talked about the advantages of patents, its disadvantages. Now we want to look at an alternative to the patent system. So it's not every innovation that qualifies for patent protection, solely because some innovations do not meet the three-tier criterion that is used to file for patent protection, where we are looking at novelty, industrial applicability, and the inventive step. So some innovations are incremental, which means they are not novel, and for that reason they can't qualify for patent protection. So there's a lesser threshold of protection, or what in other terms is preferred or referred to as the petty patents. So these are utility models. They are there to protect minor innovations or incremental innovations to already existing technologies. So utility models recognize these minor improvements on existing products, and as a way to reward these innovators, they are granted utility model protection status. So the requirements for utility models, they are not that stringent or that tough as what is required for patents. The term of protection is comparatively shorter and varies from country to country. Then the registration process as well, it's cheaper, it's faster. The fees for obtaining and maintaining these, they are also quite cheaper as compared to patents. However, it's very unfortunate that not all countries in the world have these utility models laws. And even in terms of international agreements, it's the same thing as well. There are no international agreements that really enforces or forces people to recognize utility models. I know with ARIPO, with the Harare Protocol, which also recognizes the need to protect utility models, And one thing about utility models is that they are more of an enabler or more of a ground that enables us to develop our innovative ability. It allows us to nurture our innovators so that they meet or they develop the requisite skills for them to meet the patenting threshold. So utility models are very important, especially for developing countries like Zimbabwe and other African countries. Because if you are to look at the patent filing statistics, you will realize that in terms of the statistics of the filings that we get from Africa, they are very limited and they are very few. The numbers are not that pleasing. So our countries should have these laws in place that enables the protection of utility models. I know for Zimbabwe, it's very unfortunate that we have a protocol that is used by the regional officer RIPO to protect patents and utility models, but as a country, we don't have a utility model in place to enable us to file or to enable our innovators to file for utility model protection. So this is another type of IP that is there. So we've looked at patents, utility models. Now we want to look at the third aspect, which is industrial designs. Industrial designs are there to create the decorative or the ornamental aspect of an artifact or an article. They are there to protect the decorative aspect, the make and feel good aspect of articles or items. They are there to protect the configurations of items. So anything that is pleasing or appealing to the eye can be protected by industrial designs. So industrial designs, they can protect one-dimensional items, two-dimensional items, three-dimensional items. So you realize that there are items or creations that can be protected by patents. Then you can also at the same time file for industrial design protection. You can also at the same time file for a copyright protection. So you can even protect your innovation with different types of of IP rights. So this is more like ring fencing your technology or innovation so that if someone wants to infringe, it becomes very difficult. So industrial designs, they protect the appearance, the shape, the configuration, and the pattern. So we have items like cloth designs, basket designs, shapes of bottles, shapes of shoes. All those items can be protected by by industrial design. These are other examples of two-dimensional design that can also be protected by by industrial design. And these are three-dimensional designs that can be protected by by industrial designs. Then the other items that can also be protected by three-dimensional designs can also be seen in these images that are presented here. Tattoos, you can protect them with industrial design. Shapes of phones, shapes of icons on phones and desktop, you can protect them with industrial designs. So application of industrial designs protection is very broad. You can protect packaging containers, you can protect furniture designs or household goods, you can protect jewelry designs, you can protect electronic designs, you can protect textile designs. All these qualify for industrial design protection. So the reasons for protecting industrial designs, they're also the same as the ones for protecting patents or utility models. You want to benefit from your from the fruits of your labor. So you want to benefit economically from the work that you have put in coming up with a design. You want to prevent unauthorized access or unauthorized copying or imitation of your designs by third parties. You want to encourage creativity. So all these are the benefits or the reasons why we protect what our intellectual property rights through industrial designs. And in Zimbabwe, the registration test for industrial design is done in two parts. One, the design has to be new. Two, the design has to be useful. So the design must be practical. It must have industrial applicability. It must have a practical use for it to be protected. It must be novel, which means no one must have presented or created a similar design before. So this is the criteria that is used to protect industrial design in Zimbabwe. And the period of protection varies from country to country. Some have very short periods of protection, some have very longer periods of protection. And in Zimbabwe, it's 15 years, the term of protection of for industrial design. Now we want to look at the other aspect or the other arm of intellectual property, which is trademarks. Trademarks protect a wide variety of things that are used to create brands or that are used to create well-known items. So trademarks can be made of a combination of alphabetic characters and numbers, words and phrases. They can be made of smells, they can be made of slogans. A combination of items can be used to create trademark. So some of the popular trademarks that we have in the world, with Facebook, we have names like Messi, names like Manchester United, Real Madrid, Pepsi. All these are examples of of trademarks. And you can even create your own unique trademark. Actually, every business must have a trademark that is registered so that it allows or it enables consumers to know and be able to identify the brand.